When appointing a guardian ad litem helps, and when it doesn't. Utah courts sometimes appoint a guardian ad litem in contested child custody cases under Section 78A-2-705 or 78A-2-803. Parents often misunderstand what that means. A guardian ad litem, or GAL, or PGAL, when the appointed attorney is a private guardian ad litem, is an attorney appointed to represent the child's best interest. I'll refer to GALs and PGALs collectively as GALs for simplicity's sake. The GAL may interview the child, review records, speak with parents and teachers, and make recommendations to the court. The GAL is not a neutral mediator. The GAL is not a custody evaluator, and the GAL does not decide the case. The judge remains the decision maker under. GAL recommendations can be influential, but they are not binding. Courts are not required to adopt them. When can a GAL help? In cases involving serious abuse allegations, disputed child preferences, or high conflict where basic facts are unclear, a GAL may, note that I said may, a biased and/or incompetent GAL is worse than worthless. Provide focused insight. The GAL can help to narrow issues, note that I said can, a biased and/or incompetent GAL is worse than worthless, and can, note that I said can and not always will, communicate child-specific concerns efficiently. But unless the GAL is paid for by the state, the appointment of PGAL increases cost. Fees are typically allocated between the parents. The appointment of GAL can lengthen litigation. It also introduces another voice, and not always a neutral or competent one, into an already adversarial case. Some parents request a GAL, believing it will vindicate them or expose the opposing party. That expectation is risky. A GAL's assessment may not align with either parent's narrative. It is also important to understand the evidentiary structure. A GAL report does not replace admissible evidence, or at least it shouldn't. What happens in actual practice doesn't always adhere to the rules and laws in place, sadly. Parties retain the right to present testimony, cross-examine witnesses, and challenge conclusions. Due process still applies, but don't kid yourself if you believe the courts don't place a great deal of trust in GALs, even when it's not warranted. So, before requesting a GAL, ask yourself, what specific issues requires investigation? Is there something a GAL can clarify that ordinary evidence cannot? Is the cost proportional to the benefit? In some cases, not all, the answer is yes. In others, far more than the legal system will admit, conventional discovery and the evidence produced by it is sufficient. A GAL is a tool. Like any tool, a GAL works best when used properly and within its limits. It is not a magic solution. Used properly, it can help. Used reflexively, it can complicate matters without improving the outcome. Used without subjugating the GAL's recommendations to scrutiny, it can harden superficial impressions into de facto findings, displace the court's independent analysis and judgment, and give the appearance of evidence without the safeguards that make evidence reliable.